Am I audible and visible?
Yes, I think it's perfect.
Okay.
Yeah, thank you.
Hello.
Hi, Deepti.
Hi, is that Utkarsh?
Yes, Deepti, this is Utkarsh.
Hi.
Deepti, quickly check your mic. So mic is fine. The video as well. Oh, I think that's perfectly fine.
Is it okay?
Yes, this is
We
perfect.
just did like a dry run, Jinal, and on the lighting and everything.
Right.
Okay.
Right.
Okay.
Wonderful.
Nice. Chalo, good. Everyone can see me. I'm not using Bluetooth headphones so that there are no issues or lags when I'm talking. So hopefully.
Oh, this is perfect.
Yeah.
Deepti.
No,
Thank you so much.
because it happened a lot when Priyanka was giving her masterclass, and she was on her Bluetooth headphones, and they usually create a kind of lag. So
right.
Gina is visible. All good.
Yes. Oh, sorry.
Hi, Gina.
Hi.
I think the video and audio both is perfect.
Same here. Chalo, glad.
Awesome.
Good. I
Sure.
see.
So, Deepti and Gina, we
I see
start the session around 4ish.
I see a couple of your colleagues on this.
Right.
Call.
So I'll just introduce possibly. Ipshita will be moderating the session, so starting the session basically. Satish is one of the co-founder of SkillxPro.
Okay. Hi,
so
Satish.
he's there,
Hi, Ipshita.
So,
good to meet you.
Hi, how are you doing?
I'm fine, thank you. Hope you're doing good too.
Yeah.
Wonderful. So, Deepti, all our users are on two platforms. One is on YouTube and our platform SkillxPro, right?
Okay.
So, Gina would be able to pick up the questions from YouTube. So, we are already live, in fact. We'll start the session at 4, sharp at 4.
Okay, sounds good.
Yeah. Gina, you want to try sharing the presentation?
I was just doing that. Yeah. I just want to do that.
Did you guys get my corporate profile, Gina? Did we send that?
Yes.
Thank you. It was a rather busy evening, so I couldn't do it myself.
Can you guys see my screen?
Yeah, I think the presentation is fine. Yes.
Okay.
This is how it's going to look like.
I think we're good.
So, Gina, by any chance, do you have the PPT version of this?
Actually, we did it on Canva, so probably no.
Oh, okay. No problem. That's fine. I think this is fine. Sure. So I'll just put back the banner until we start, and we'll start at 4.
Sure, perfect. I can see the YouTube thing. There's no lag, right? And there is no echo.
No, so you just keep yourself on. Just keep the YouTube on mute. There will be no.
Yeah, Jinal, it's all good. Is this better? Jinal,
Yeah.
is this better? In
Yeah.
terms of, I've reduced the lights above me.
No, it's better. It's better.
This, I think, looks better.
Looks better.
Hi, Deepti, Jinal, can we start the session?
Yes.
Yes.
Great. Ipshita, over to you. You can start the session, please.
Hi, my name is Ipshita Singh, and I would like to welcome you all to this masterclass on due diligence. Now, why have we joined this session for this masterclass, and why is this topic important? As a corporate lawyer, especially while we work as interns or associates in law firms and corporates, due diligence generally forms part of the major work that we carry out. In fact, in some cases, due diligence may account for more than 70% of your billable work as young lawyers. Therefore, in order to be profession ready, it is important that we understand and master the skills required in the due diligence processes. Before we move on, I'd like to bring in Mr. Utkarsh Kumar, co-founder of SkillxPro, who will be briefing you further about this masterclass as well as about the full-length course that we have on arbitration. Over to you, Utkarsh.
Great. Thank you so much, Ipshita. Now, so just to brief you, as Ipshita mentioned, that due diligence forms one of the, major part of the work we carry out as transactional lawyer. Especially when we talk about, when we join as associates or while we are interning, this is one of the major work which is delegated by any partner or any senior while we are working at the junior level. Now, it's not a straightforward way to carry out a due diligence. It differs from transaction to transaction. Obviously, the senior will guide you through the process. But the idea of today's session is for you to understand the very basic what due diligence is, right? How the process is carried out. And at the same time, understand some nuances, some skills which are surrounding a due diligence process, so that tomorrow when you are working as intern or associate in any firm, any company, you know where your senior is, what kind of work is he expecting, and how to start with it at the very outset, right? So that is what the purpose of today's session is. Ipshita, can you? I'm back to you. Please introduce the speakers for today.
Sure. Now, let me introduce you to the mentors of this session who have a plethora of knowledge and experience as corporate lawyers and have carried out several due diligences in their career. Our first mentor for the day is Advocate Deepti Sarma, who is a practice lead, general corporate and advisory at Anand Anand Khimani. Deepti has led end-to-end corporate transactions, particularly in relation to mergers and acquisitions and private equity deals. She has advised and represented clients over the years on a range of matters, including general corporate advice, commercial contracts, and employment laws. Thank you for being with us here, ma'am.
My pleasure.
Our next mentor for the day is Advocate Jinal Shah, who is an associate at Anand Anand Khimani. Jinal started her journey with DSK Legal and thereafter moved to Veritas Legal. In a span of 3 years, she has assisted various clients on their corporate transactions such as mergers and acquisitions and private equity deals. Prior to joining Anand Anand Khimani in 2020, she pursued her LLM in intellectual property from Boston University, USA. Thank you for joining us here today.
It's a pleasure.
Before I hand over to the speakers, let me quickly brief you on the format of this session. First, the speakers will delve into the subject of due diligence. This will be followed by a Q&A session. The audience can leave their questions in the chat section on YouTube. We will be taking them at the end of the session. Over to you, speakers.
Awesome. Thank you so much, Ipshita, for the introduction. And it's a pleasure to be a part of this session. Due diligence, like Utkarsh mentioned, is a very integral part of being a corporate lawyer. And I've had the opportunity to be a part of several big due diligences as a part of massive investments. And I hope that I'm able to leave the listeners with some tips which they can use when they start participating in the due diligence process, or if they are fresh associates who are already doing the process, if I can leave them with some tips which will help them through the process a little more easily, right? A lot of learning as far as due diligence is concerned is experience based, because as a corporate lawyer, you are going to the due diligence that you do will always be sector agnostic. It's not that you're going to be doing a diligence on one particular sector at all times. So it's a learning experience, and it's something that you learn being a part of several diligences over a period of time. However, it doesn't hurt to have some tips, some thoughts, or some line of thought on how you can approach this exercise, and that's what I'm trying. I hope I'm able to do today. So, Gina, you just want to put up the presentation?
Yes.
So today we are going to deal with the very basics of due diligence. Okay, I'm going to keep my lingo very, very simple and easy to understand. And as you go through the slides, I think you'll see how reader friendly it is. And I hope I'm able to explain it in a similar fashion. We are briefly going to be discussing the following topics today. I'm going to first briefly delve upon what a due diligence process is. What is Gina? I don't think the slide is scrolling.
Is it scrolling now?
No. Yes. The next one.
Is it scrolling?
The one before that. I think there's some. Yes. So today, an overview on what we're going to discuss. What is due diligence and why is it important? I know you may have heard from your seniors, from people whom you've worked with. You may have been a part of diligence as a part of your internships. But I'm just going to leave you with with some quick thoughts on why it's important to undertake a due diligence exercise. We're then going to deal with precursors of a due diligence, as in what is it that you need to keep in mind before you exactly start a diligence process. The areas of due diligence, which is obviously going to be the meat of this discussion, under which we're going to discuss every area which is typically covered as a part of legal due diligence. And lastly, I'm going to leave you guys with some tips on how report writing can be undertaken, something that more often than not, we don't really focus on, but drafting the report is also equally important as being able to do a due diligence, right? So that's something that I'm also going to be delving on today. So let's start. What exactly is due diligence? Due diligence is nothing but an investigation process, right, in relation to the affairs of a company. Now, think of yourself as going to buy, a very expensive 4K OLED TV, right? It costs like 70, 80K. And what do? You just go and buy it off the rack? No, right? You're going to look through websites, you're going to look through reviews, you're going to look at price comparison. Are you paying a premium over what the competitor is offering? Is there any up that you're getting by paying more money? Is it a right fit for your room? Which is the room that it needs to fit in? I mean, there are so many considerations, right, before there is a high value stake as far as even a consumer is concerned. So a due diligence is nothing but a similar exercise which is undertaken by an investor. But obviously the stakes are high, the exercise is different, but the ultimate purpose is the same. That is to see if there is value for the money that is going to be invested in the company. Okay. Now, due diligence more often than not is always spoken in a buyer parlance and investor parlance. So these are some terms that I'm going to be using very often throughout this discussion, and you guys must get acquainted with this. So we have an investor, right? We have a target entity, that is the entity in which the investor is going to make the investment. And every target entity, like will always have shareholders or promoters, right? A larger part of the due diligence exercise is, as far as the target entity is concerned, is governed by the management. They take full onus on undertaking the due diligence exercise. Okay. What you do is act as a counsel for the investor by undertaking the legal due diligence exercise. Clear? Now, is it an exercise which is important only for the investor? Of course. It's more important for the investor because the stakes are high. He's not going to be paying crores and crores of money without knowing what exactly is going on. But it's as important even for the target entity, that is the entity which is going to receive the money. So, for example, if the target entity is a brewery company, right, manufactures alcohol, there is an offer for purchasing the entire company from a US-based entity. Now, the Indian entity is not going to blindly just jump into the deal, right? Because they just see the color of money. No, that's not how it's going to work. What they may want to know is what are the jurisdictions in which they operate? What is the brand value? What is the value that they will add to the Indian entity if they actually acquire the Indian entity? What are the jurisdictions they operate in? How much traction will their target company get? So there are equal considerations for the target entity as well, but they are largely more commercial than legal. All right. So today the discussion is going to be centered largely around you being counsels for the investor, right? Because that's where most of your observations and areas of due diligence and analysis steps in. So a larger part of the discussion today is going to be focused on think of yourself as counsels for the investor when I see through this discussion today. All right. Now, why is the due diligence important? Quickly just running into the few points as to why you're doing this whole exercise. It's very important for you to know what is the value add you are giving as lawyers to your client, okay? Firstly, it's risk analysis, okay? You are going to understand the strengths, the weaknesses, the competitive advantage. You're going to help your client, the investor, understand all of this when you undertake a due diligence exercise. Second, very important point, identification of red flags. Okay, what are red flags? This is what we call make or break, right? These are the kind of issues which have the ability to, get principals to stop discussing the deal. These are what we call deal breakers. So a due diligence exercise is where you are going to be able to identify red flags. Okay, so that's the second reason why you do a diligence. Thirdly, valuation support. Now, valuation, of course, is a discussion by itself because there are several nuances to it. But what is exactly valuation? Okay, simply put, it is a value which the investor and the entity or the promoters have agreed when they have in principle decided to come together. There has to be some basis for them to begin the due diligence exercise, right? So that valuation is what we call as the initial valuation, which is decided between the investor and the target entity and the promoters. Okay. Now, what you do when you do the due diligence exercise is render support to your investor by saying that, yes, the valuation that you've done is more or less accurate, or no, there are perhaps some things that you need to consider. Okay. So for example, typically an investor and promoters and the target entity will sign an in-principle document in what we call, I don't know how many of you are familiar with terms like term sheet, memorandum of understanding, letter of intent, right? This is the first commercial document that is signed between the investor and the seller entity or the promoters of the seller entity to enter into an in-principle understanding to begin all of this, right? That is where they would have typically set out some basis for arriving at a value which the investor is willing to pay the company. Your job as an investor lawyer is to tell your client that, yes, the valuation that you've agreed to is correct, or the grounds on which you've agreed more or less look good. Okay, so valuation support is another very important reason why due diligences are undertaken. Now, the next 3 points are largely softer points, but in my view, very important because I have actually seen all of this also become make or break in terms of going ahead in, with the transaction itself. Firstly, of course, is information from the target, right? When you sign the in-principle document, okay, there is very little information that you have as an investor. Okay, the investor will typically do this without lawyers because it's a very commercial document. So it's not like they're going to cite all the possible documents that they can before they are actually going ahead and signing the term sheet. A due diligence exercise is where they get more visibility on what exactly the company has or what are the affairs, what is the health of the company. So that's why it's important. Similarly, personal interaction. Now, when you begin a due diligence process, you interact with several people in the company, not only you, but also your client. Okay, there are going to be management discussions. You're going to deal with the CEO, the CFO, heads of departments. Each of them are going to answer questions for you. Many a time, this helps them identify synergies, right? Okay, which is my next point. It helps them identify whether there exactly is a mind mesh in terms of them taking the business forward. Okay, you have to look at it like a target entity, and suddenly there's an investor who's going to put money into the company, right? It's like a marriage of sorts. So it's very important to understand that you actually are going to synergize and bring value to each other. So these kind of interactions always help an investor understand whether they really want to go to the next step, which is drafting the transaction documents, which is why a due diligence exercise is very, very important. Typically, you can move to the next slide. Typically, a due diligence exercise lasts for about 4 to 6 weeks, depending upon the number of entities that you're going to do a diligence on. But that's enough time for the investor to gauge on how well they're going to synergize with the target entity and the promoters. Now, what are the types of due diligences? Okay, there's legal, which is what obviously we're going to talk about today. But there are a host of other diligences. Due diligence is a very broad term which is used across multiple disciplines. Okay, so you have commercial diligences, which means you're going to look at sales, you're going to look at competitors, you're going to look at products, product value, a very commercial level of the diligence. Financial diligence, as the name suggests, the numbers, right? You're going to look at the account, the P&L, the balance sheet, operating expenses, working capital, so on and so forth. Forensic diligences, not very much in vogue in India as yet, but it's picking up pace. Where there's usually an investigation that is done on the promoters at the target entity to see if they're involved in any unlawful activities. Intellectual property many a times overlaps with the legal diligence, right? However, if it's a company which is very intensive in IP, then your client, the investor, may many a times want to do a separate IP diligence, like they call it. So, for example, if it's a pharmaceutical company which has a host of trademarks and patents and applications and registrations and so on and so forth, pharma companies are usually very intensive in IP. So, at that time, the investor may want to do a detailed assessment of the trademarks, a detailed assessment of the IP and the value it renders to the business because it's so instrumental to the valuation. So there may be times when IP may be done separately. It may not form a part of the legal due diligence process, but more often than not, if the diligence is not very IP heavy, you will cover it as a part of the legal diligence itself. Similarly, environmental diligence. Now, if, for example, the target entity is an entity which is engaged in, say, disposal of hazardous waste, very, very important to have an environmental diligence done because there are a host of compliances under environmental laws which you then need to be mindful about. Again, why? Because you need to know that they are compliant enough for them to take the business forward. So the sector in which the target entity operates is what decides the extent to which you will do the legal due diligence. Okay. Today's discussion is largely going to be obviously around legal diligence, like I mentioned, and this brings me to my next most important topic, which is what are the precursors to a due diligence? What is it that you need to keep in mind before you actually start the process? Okay. Review the documentation between the investor and the investee. Like I mentioned, there will always be an in-principle disagreement or a document between your investor and the target entity and its promoters, right? There will be some understanding that will be set out between them. There will be some structure that they may have decided through which the investment needs to happen. It's very, very important for you to review that term sheet and be on top of it to understand what exactly the transaction is about. Do your homework. Okay, we are in an internet age. Okay, if you know your target entity, you know the promoters you're going to deal with, do all the possible homework you can, right? Read up everything about the company, read up everything about the promoters, access public documents if you can, wherever possible, and try and get some information. Like you have the Ministry of Corporate Affairs, right? You have the trademark registry, conduct searches, see, get some basic information about the company so that you can get a better understanding of what you're getting into. The third and the most important step is management discussions. Okay, I consider this as a very, very important piece in the diligence process because this is an entry into the target's world. Okay, nobody knows the company better than the management. You can't just deep dive into a diligence without knowing head or tail about it. And this discussion, after you've done your basic homework, is very, very important. Always schedule a management discussion after you have some information because you don't want to look stupid, right? Or you don't want to look like you're speaking to them without any knowledge about what the company is about. So always do your homework and have a discussion with the management and get to know more. Okay, everything from a business side, from a commercial side, from a legal standpoint, get an idea of how old they are, how have they been functioning, how do they normally do business, what does a normal day in their business look like, right? So these are things you must always understand because, like I said, it helps you understand what you're going to get into. What is it that you need to focus more on the diligence? So, for example, many a times when I have had management discussions, I have realized that, oh, this diligence is going to be very contract heavy. I need to keep a good team to review the contracts. Or, oh, this is going to be very license intensive. So let's keep a team separately to do the homework on that. So I think the management discussion is a very good beginning for you to understand more about how the due diligence is going to pan out. All right. Now, the next important thing after this is the number of entities and the period of investigation. Before you begin the diligence, it's very important for you to understand group structure. You're not always going to do a diligence of a single company. Okay. There's going to be a holding company. Then there are going to be companies below it. Okay. It's very important for you to understand how many entities you're going to do a due diligence on. Okay. And I'll tell you why. Many a times, for example, like I mentioned, the MOU which is executed between the parties, they will say that X part of the business is what they intend to keep out of the transaction. So if there is one main holding company and then you have several companies under its umbrella, there may be one company undertaking a business which you really don't need to make a part of your review, right? So you need to be very cognizant about these facts, which is why reading the term sheet is or the preliminary document is very important because it is like a guidance note for you on how you need to proceed. So number of entities, that is which entities you need to do a diligence on, and the period of investigation. How far back do you need to go, right? The typical time is 3 financial years. Okay. More often than not, your client is going to insist on going back 3 financial years. But again, it's very, very important for you to understand how far you need to go back. Last but not the least is preparation of the preliminary checklist. This is the first document which is going to be your insight into the company. Okay. After all of this that I just mentioned as precursors, you are going to prepare a preliminary checklist, right, which sets out all the information that you need from the company. All right. It is going to basically set out a host of questions which you are going to ask the management to understand more and to get what is the purpose of a checklist. Is A, to let the company know what is the information you're seeking. Okay, and also for them to be able to organize the data according to how you have asked questions. Okay, now I have a few tips here on how you must, or rather, what are the definite things that you need to keep in mind when you prepare a checklist. All of these you will always find handy. You will have a senior who will tell you that, this is a template of a checklist. Iske basis pe aap kar lo. Okay, but what is it that you need to keep in mind? Or what is it that you definitely need to bear in mind when you're looking at a checklist? Okay, you need to keep the questionnaire, that is, you need to keep the checklist very, very broad. Okay, the checklist has to be so broad that it elicits all the responses that you want. So, for example, if an Indian entity, okay, in course of management discussions that I mentioned, if the management mentions that they have a joint venture with a company in the US, okay, so you know that they have joint ventures. But when you send your list of questions, the question that you will ask is please provide me with the agreement with the with the company in the US. Hello?
Right. Deepti, I think we have lost Jinal.
Yeah.
Possibly you want to continue. We'll, the moment she joins, we'll resume the presentation.
Okay. Because
I'll coordinate with her in the background, Deepti.
Sure. I actually saw her screen freeze. I realized she's going to drop off.
Right.
So, so just like I was mentioning, so the questions that you ask have to be very, very broad. Okay, they have to be broad enough for you to not. So, in the example that I gave you, okay, it can't be that you only ask for the agreement with the JV, for the JV that they have formed with the US entity. No, your intention is to get that document and also all other JVs that they may have formed with other third parties. Correct? So it's very important to keep the questionnaire broad. Second, categorize your questions section wise. You do not want a running list of questions, haphazard list of questions, asking them different things. No. How do you think these things work? Your checklist goes to different departments of a company. There's going to be an IP head. There is going to be an HR head. There's going to be a company secretary. Okay, so the management is just going to send out the checklist to those different people and get them to put the documents together. So you can't have a haphazard way of asking questions. The questions have to be very organized for you to get organized answers. All right. So always bear in mind that everything is categorized section wise. Now, what are these sections? That's what our areas of due diligence is. We'll come to that. But being organized is the key. Next, keep the checklist flexible. Always leave room for you to be able to ask more questions. There is a reason why this is called a preliminary checklist. Okay, this is not the be all and the end all. This is the first set of questions that you are actually going to ask the management. You need to have sufficient protection for you in the checklist to mention that you have the ability to ask more questions to the management as and when more and more documents are provided by the company. Okay, so keep the checklist flexible to that extent. And lastly, set a timeline for responses. Now, you are going to send out the checklist, the company is going to start putting all the information together, but it's very important for you to also get a response to your checklist. Okay, a lot of this is very flexible. Okay, more often than not, if it's a company which is not really having prior experience in diligence, they may not really be able to give you a very detailed response, to your checklist. They may need a lot of hand holding, but always try and ask for a response to your checklist before you start the review process. Again, while it gives you some headway in terms of what are the documents that you're going to review. More often than not, from a senior's perspective, okay, if I see responses to a checklist, I see which section of the report is going to be very heavy and where we are going to need more help. Okay, so which is the reason why it's important to get responses, but there's no hard and fast rule. Like I said, many a time the management is not very equipped to be able to do it. But if you get it, then it works brilliantly for you before you start your exercise. After this, once your preliminary checklist is actually circulated to the management, the big, massive exercise of putting together the documents begins as far as the target entity and the management of the target entity is concerned. Okay, this is what we call as setting up of a data room. Now, there are two kinds of data room. Okay, one is a physical data room, where this is something that used to be very, very commonly done until a few years back. Okay, we used to have teams visiting the offices of the company. You sit there, you interact with the management, you review documents there, leave the documents there. You're not permitted to leave the premises with any documents. So that used to be one kind of a way to do due diligence, is because, and it used to be very tricky because you will never, what you read there is what you assimilate, right? There are no photocopies, there are no screenshots, there is no downloading. You have to see and assimilate the information physically. Okay. The other kind of data room, which is where we have all largely migrated today, is the virtual data room, and the pandemic has only added to the importance to this. Okay. Like the name suggests, it's virtual, it's all online. All the documents are provided in soft copies. Okay. And all of these documents are usually shared through online data sharing platforms. Okay, you have Dropbox, you have Google Drive, you have intralinks, depending upon how secure the company wants the data to be. Okay, you will usually have data being shared on virtual data rooms. More often than not, lately, all your experiences are going to be centered around being a part or doing a diligence from a virtual data room. And believe me, It has a lot of advantages because you have the ability to download a document, you have the ability to revisit a document, you have the ability to analyze it with a senior and understand more, all of which you never get in a physical data room. Also, target entities now are migrating towards virtual also for another reason, which is mainly cost. Okay, when you do a physical exercise, okay, the company, the target entity typically bears the cost of the diligence. So usually, so then you are going to have lawyers, you're going to have chartered accountants, everybody coming and sitting in the office, and then parallelly you have all your people working there, and everybody's thinking, "Arey, in log sab log kahan se aa gaye?" Because you don't want everybody to know about something when the deal is not even happened, or when it's not even reaching a stage when you want the people in the company to know. So more often than not, now managements prefer to have a virtual data room because it keeps things confidential. It keeps things between the management and the investor, at least till the diligence is done. And data sharing becomes very, very easy, and it's very cost effective for the company because they don't have lawyers and accountants and other people sitting on their heads. And everything is virtual, and all they need to do is keep having calls or maybe 1 or 2 physical meetings to be able to sort out all issues. So the trend these days is mostly towards virtual data rooms. Which brings us, once the data room is set up, okay, by the company, it brings us to the areas of due diligence. Okay, what are the different sections or areas of due diligence that you are going to typically deal with? Okay. We'll just set out, all of these are points that I'm going to discuss today. Structure related, there's company law, there's contracts, licenses and permissions, finance and indebtedness, human resources, real estate, IPR, litigation. These are what are typically areas of diligence that you're definitely going to review documents on. Okay. So the first, and according to me, the most important part of the legal due diligence is identifying structure-related issues. Now, I consider this as one of the most important areas of a diligence, and this does not depend on any info that you get from the company many a times. Okay, of course, reviewing information may add to what you think is an issue under this particular area of the diligence, but structure related issues, more often than not, again, I'm going back to the main document that has been executed between the investor and the target entity, which is the term sheet. Okay, many a time they may have agreed, say for example, the investor is a non-resident entity and the target entity is an Indian entity. Okay, they say that we will invest, we will acquire 80% of your company, and the target entity, say for example, is in the defense sector. Now, you have foreign direct investment guidelines which limits FDI, okay, foreign direct investment in the defense sector to 74%, for example. So there is a fundamental issue in what your client is willing to do, right? So these are things that you can identify as a part of structure related issues. Okay, it helps you identify if there are any fundamental problems in executing the deal itself. So it's very important for you to be able to understand whether there are any compliances. Usually there are compliances with regulatory bodies like the RBI, SEBI, CCI. Like for example, if you've read the papers today, the Sony Z merger, they're saying that it is going to be, they have signed an in principle term sheet, and it's going to be subject to approvals from NCLT, that is the Company Law Tribunal, and the CCI. So these are what I mean by structural issues. You're going to need prior approvals before you go ahead and consummate your deal, before you go ahead and actually invest in the company. So these are things you must be cognizant about even before you begin the diligence, if it is possible. Many a times you may also be able to identify some of these issues once you review a little more of information that the company provides. The other part of this is also meeting some requirements for regulations framed by, say, statutory bodies. Now, for example, you have something like a TRAI, okay, which is the Telecom Regulatory Authority of India. There are a host of legislations which are covered under TRAI. Now, if your target entity is in the telecom sector, okay, other than all these RBI, FDI related issues, there may be some regulations or there may be some laws, okay, in the telecom sector, which may have some inherent requirements for the investor to complete or for the target entity to complete even before the deal is done. So you need to look at it in a very holistic perspective as to what is it that's going to, if at all, be an impediment to the deal. You need to do your ticks and crosses in terms of the structure of the deal for you to be able to be assured that the structure that the investor is contemplating is workable. A few tips that I can leave you with when you have to kind of identify issues under this area of the report is read the term sheet. Okay, I think I just mentioned that when I began. That is the fundamental document for you to understand how the investment is going to happen. Okay, so you must reach the preliminary understanding between the investor and the target entity. If there is no understanding, speak to your client, ask them how are they planning to invest, what is the potential structure they expect. Because when you are putting pen to paper, you must analyze these issues and highlight it to the investor to tell them that there could be some fundamental issues. This doesn't come from any information from the company. These are fundamental issues in even doing the investment. All right. Which brings me to the next point, which is check connected laws. Okay. Like I said, when you know the term sheet, when you know the sector, when you know how they're going to do it, you must check all the laws surrounding this. You must check if there is something, okay, that you are able to identify as a potential impediment to the investor even doing the deal. Chat with financial advisors. This is very, very important for you when you are trying to analyze structure related issues. Okay. Why? Because more often than not, the investor not only legally but also wants a tax and account financially efficient structure for them. So it always helps to have a dialogue with the financial advisors because they may be able to throw some more light to you on how the investor is proposing to undertake the investment or why they want to do it in a particular way. Because, say, for example, it's tax efficient or it is efficient from them from an accounting perspective. So that also helps you appreciate why a particular structure is in place, right? So these three are some tips that I always follow when I have to identify structure related issues. And I think you must keep that in mind, okay? Because all the other areas of the diligence are entirely dependent on the information that the company provides. But please be mindful that this is one section of the report which is entirely up to you as a transaction lawyer, as an attorney who is a part of, say, PE M&A deals. It's very important for you to be able to identify structure related issues or legislative roadblocks which the investor is going to face, right? Now let's start with the other areas of the diligence, which is largely going to be, so these are how you're going to ask your questions. So your first section in your preliminary checklist, for example, would have been company law, for example, okay? And you would ask like a host of questions under it in terms of company law related questions. Now, what are the usual documents that you're going to cite as a part of this section of the diligence? Okay. Typically, the target will provide you with the shareholding pattern, as in who the shareholders are, how many shares do they hold, what is the overall percentage holding, etc. Shares, then residency status. That's something you will come to know, whether the shareholders are resident, non-resident. Very, very important for you to understand all this because foreign exchange regulations analysis is very, very critical for you during a diligence. So residency status is very important to understand as a part of this section. Share certificates, minutes of the meetings. Again, they are the windows to the soul of the company. Okay, you are going to know everything that the company does by reviewing the minutes. Now, what are minutes? They are your documents which set out the board meetings, the shareholders meetings. There are also various committees that are formed by companies many a times. So minutes of all of those, because they tell you the true affairs of the company. All right. That's going to tell you what the company has done for the period for which you're actually looking at the diligence. Okay, so it's very important to review the minutes of the meetings with a fine-tooth comb and get a complete grip on it so that you know exactly what has happened in the company over the past 3 years, say, for example, if you're doing a diligence for 3 years. Companies Act and RBI compliances. Now, this is a company law related section of the report. So obviously, there are a lot of compliances under the Companies Act that the company is required to do. So, if, for example, there's a change in the registered office, or if they've created a charge on a property, or there's been a resignation of a director, all of these require compliances with the registrar of companies, and that is going to be another set of information that's going to be provided to you. Then RBI compliances, if there are non-resident shareholders in the company, there is going to be an angle of RBI compliances, right? And that is something that you are going to need to examine as well. The next point is the charter documents. Again, with the minutes, another very important set of documents you need to have a complete grip on. Okay, What are your charter documents? The memorandum of association and the articles of association. The likelihood of you having already seen it would be high if you've done an independent search and done your homework. If you remember, that's what I said right in the beginning. So if you manage to do an independent search and manage to get it out, then you may have already seen it. And this obviously keeps you more prepared in terms of what are the issues that you need to highlight. But of course, it's a very important set of documents that form up, as far as company law is concerned, a very important set of documents for you to understand rights of shareholders. The next important set of documents are investment documents. Okay, what are investment documents? Now, if the target entity has other shareholders, okay, who have invested in the past, they may have signed some agreements with them, right? So those agreements are what we call investment documents. Why is it important? It's very, very important for you to look at it because it tells you what are the rights that the existing shareholders enjoy, okay, which you may want the investor to enjoy as a part of the document that they prepare, right? Or you may want to tell them that, there are these ABC rights which they have, so we may need to renegotiate this. So investment documents, again, if there are multiple shareholders in the company who are not say the promoters, other than the promoter group, are very, very important documents to do. Now, what are the common observations, okay, that you will see when you review these documents as a part of the company law diligence? The first thing that you will typically identify is anomalies in shareholding, okay? This is something you must catch. So, for example, if they're given you a particular shareholding pattern, okay, saying that there are 4 shareholders, A, B, C, D, 25% each, okay? But you have seen a minutes of the meeting, you've seen a board meeting in which they have recorded that B has transferred his 25% of the shareholding to C, okay? Which means there are only 3 shareholders. So when you look at all these documents, these kind of anomalies now you will be able to identify. So that is why all of these documents are important for you, and shareholding is the key for your client, okay? The title to the shares is what the investor is actually going to be interested in. Or if there are, if there are any issues in the title, the investor is definitely going to be interested in it. So as investor counsel, it's very important for you to focus on whether the title to the share is good and accurate, okay? Secondly, second set of common observations are delays or non-compliances. Okay. Now, like I said, there are Companies Act compliances, there are RBI compliances. Now, if there are any delays, you will be able to find out. If there are filings which have not been made. So, for example, you see a board resolution to say that a particular director has resigned, but you have not seen a filing with the ROC to record that. That is what you're going to spot over here. Okay. So the mapping between everything you see will lead you to understand whether there is actually a non-compliance or not. And lastly, existing shareholders' rights. This is something that I already discussed. When you see the articles of association, when you see investment documents, it helps you understand what are the rights that the existing shareholders have, which you may want to keep the investor, your client, informed about. Okay. Now, let me leave you with some pro tips on how you can, quicken the diligence process for yourself, or what is it that you always need to keep in mind when you are assigned the company law section of diligence. Okay. Map the minutes with the ROC form filing. Like I said, the minutes are the windows to the affairs of the company. It's very, very important for you to marry the minutes with all the filings. The minutes, you need to be thorough when you review the minutes. So always pick that up first when you start the company law section of the diligence. Okay. It helps you understand a host of other connected issues. So always bear that in mind. Second, check the financials of the target. Honestly, this is something at least I personally always do even before I begin the diligence. Annual returns sub nikal karke, I always have a look at what is it that they have and what is it that they don't have. Or if not possible, I always ask the investor. They will typically, when they arrive at valuation, they may usually have financials with them already when they did the term sheet. So I always ask them to send over the financials and make copious notes to see if there is anything there which is a red flag for us or something that we need to keep in mind when we do the diligence. So one such exercise is checking the financials of the target. Okay, they will tell you a lot of things. For example, if the paid up capital has increased, Okay, if the authorized share capital has been increased in a particular year. All of these are things you will know when you see the financials of a company. So always make it a point to check the financials of the target entity very, very meticulously. Okay. Now, the next area of due diligence that you were going to typically be a part of, and which is massive usually, is contracts. Okay. You can expect the bulk of the documents to be in this section of the diligence. And more often than not, I have always encountered juniors getting very overwhelmed with this section of the report. So hopefully I'm going to help you simplify that today. I can give you with a few tips that I help them with. So before that, what are the usual documents that you are going to see? Now, contracts are very business specific. Okay, I cannot leave you with like in company law, I left you with a list of things which you will always find. That's not going to be possible because it's very business specific, right? Now, for example, if you are a manufacturing company, okay, you are going to have procurement contracts, distribution contracts, supply contracts, all of that, right? On the other hand, if you're a very simple, say, an ad agency, okay, you're going to have just, I don't know, simple agreements with third parties or services agreements. Okay, so the scope of contract is always different from business to business, which is why, if you remember, right in the beginning, I had told you something about having management discussions. That always helps you understand how the business functions, which in turn helps you understand how the contract structure is going to look like. Okay, so make it a point to understand that when you have management discussions, and before you know, this section of the report will kind of become very clear to you on how you need to do this. Okay, so typical documents that you will see as a part of contracts is client contracts, vendor contracts, contract manufacturing agreements, service agreements, like I said, procurement, supply. There are a host of contracts depending on the business of the target entity. The observations, however, are usually very, very typical. Okay. Again, this differs from contract to contract, and contracts always have to be reviewed with a fine-tooth comb because, like I said, while they are huge in volume, they are equally important for your client to know if there's anything in there that they need to be cognizant about. Okay. So pay a lot of attention when you're working on the contract section of a report. Now, what are the most common observations in the contract section? Very, very commonly, expiry of contracts. Okay, when you pick up a contract to review, please don't start reviewing and making copious notes. Always check the term of the agreement first. If a contract is expired, you are not required to review it. Okay, the observation you will then make is that the contract has expired. Okay, more often than not, beginners start reading contracts end to end, and then suddenly they reach the term provision on the 10th page and they come to know, ye to expire ho gaya. So be very careful. Expiry of contract is a very, very, very typical provision, and very typical issue that you will identify as a part of review. So always be cognizant about that first. Always check whether you're reading a valid contract. Secondly, stamp duty. Again, another discussion for another day, but you must ensure that proper stamp duty has been paid on all contracts. If there are contracts across different states, then you need to go through the exercise of checking the stamp duty for every state for that particular contract and ensuring that it's pretty much in line with what the state stamp laws actually recommend for payment, right? Why is it important? If a document is not stamped, it creates enforceability issues, correct? So it's very, very important for you to identify whether contracts have been stamped, and if they've been stamped, have they been adequately stamped? Okay. The next most important point is consent requirements. Okay. Many a times, high value contracts are going to have consent requirements embedded in them. So you will very normally see provisions that if there's going to be a change in management in the target entity, they will need to seek prior approval from the counterparty. Okay, so this then becomes what? It basically means that till the time an approval is taken from that counterparty, your client, the investor, is not going to put in the money. He will not be able to do it. Otherwise, the target will become in non-compliance of that agreement. And it's a high value contract, which means it's very important for your client also for that contract to continue because it's important to the business. Correct? So these kind of consent requirements are very important to identify, and many a times they are worded very trickily. Always consult your senior. Okay, there are times when the language is so tricky that it's important for you to take a call on whether the consent is actually required or not. Okay, you'll see a lot of language like change in management though is very straightforward. Then they will talk about change in constitution. So it's important for you to discuss it with someone more experienced and for them to be able to tell you whether this should be in fact an issue or not. But always keep an eye out for this. Then last but not the least is obviously onerous provisions. Like I said, you read contracts very, very minutely in a granular way. So there could be a lot of provisions which could be very onerous on the company. So for example, if there is a provision in the contract that you review, which says that if there is a change in shareholding in the target entity, then the counterparty has a right to terminate the agreement. Okay, I have seen contracts like that. There's no consent requirement. It just says that they will terminate the agreement. So that is very important and if that contract is very important to the business, then it's very critical for you to identify that and tell that to the investor. Correct? So these kind of provisions you must always keep an eye out for when you're reviewing contracts. Now, some tips for you to achieve contract review in an efficient manner. Okay, like I said, the contracts part of the report can always be, of the diligence can be very overwhelming, especially if it is an entity which is very voluminous in terms of contracts. Okay, so a few tips on how you can make this a more structured exercise. Ask for a complete contract list. Something that I always do. If I see the answer checklist and I know that there are going to be a lot of contracts, you more often than not be rest assured the company will maintain a running list of all contracts category wise. And if it is not there, they'll make it for you. Okay. So please ask for a complete list of all contracts that the company has and ask them to provide it to you. Now, why is it important? Now, picture this. There is a manufacturing entity. It's say across 10 locations, and every entity has suppliers, distributors, manufacturing, sab kuch, right? So totally per location, you're looking at say 100 contracts. Now, if you have a time of 4 weeks, it's physically not possible for you as attorneys to be able to review 100 contracts per location, which means if there are 5 locations, you're talking about reviewing 500 contracts. Okay, so please understand that's not what your client wants. This is where an intelligent analysis of how you need to review comes in. So the contract list that you get, uske baad you need to have a dialogue with your client. You need to ask him that, listen, these are the contracts. So the investor may then have a very sensible approach to this. So for example, if the financial diligence has said that these 5 are the top clients, these 5 are the top suppliers, these 5 are the top distributors for this particular location, then they will be able to tell you to do what we call the process of sampling. Okay, very, very critical and very, very important for you to know how this works. So what happens once you get a complete contract list is you are able to have a dialogue with your client and say that these are the different categories of contracts and these are the numbers. So would it be possible for us to sample, right, on the basis of volume, on the basis of revenue, on the basis of expense? Okay, there are various criteria that investors usually apply and they will be able to come up with a solution to you, right, in terms of how you need to review it. So always ask for a list, especially if the contract session is going to be very voluminous, and have a dialogue with your client on the approach. And before you know, you will see that the exercise is far more structured. So never get overwhelmed, but try and get a list and understand how you need to go about it. Okay. Next, check for templates. Another very important mistake we make. Okay. They'll give you 15 distribution agreements. See, please understand, as far as the target entity is concerned, you have asked for information, they will do a data dump on you. Okay. You need to understand how you need to go about it. So the question you need to ask them, for example, in this case, if they've given you 25 distributor agreements, the question for you to ask is, are all of these identical? Do you follow a standard template which you then get signed from all your distributors? More often than not, they will tell you yes. Upar niche hota hai thoda, but more often than not, we follow the same template. So that is what you need to hold on to and tell your client that it's more or less similar. So it should be cherry picked, should be sample. Correct? So it's very important for you to have this. First, try and understand from the management. Second, take that discussion to your client and then try and understand how you want to do this review. Okay, all of this before you know, once you start strategizing like this, before you know, the review process becomes a lot more easier and you are able to give more value add to your client, right? So please keep these tips in mind when you are going to review the contract section of the report. And I hope you don't get overwhelmed when you do this, whenever you do. I hope these tips help you. Moving on. Finance and indebtedness. Okay. Now, this is nothing but loans, which are taken by your target entity or given by the target entity. Now, if you have a group structure, then you could have intercorporate loans. That is, the main company giving loans to its subsidiaries and so on and so forth. Another very common document that you must ask for is the no due certificate. Okay. Now, what happens is, say, assume that you're doing a diligence over a period of 3 years. Okay. The management tells you, this loan we have already repaid. Now, you're not going to take their word for it. What you will ask them is, has the bank given you a no due certificate stating that this loan has been repaid? That's a document you need to ask for. Okay. So whenever you are told that there has been a loan which has been repaid, always insist on a no due certificate. Okay. So these are documents that you will typically see as a part of the loans section of your diligence. The most common observations from this section of the report is security provided. Now, for example, if there is a mortgage of a property, okay, it's one of the biggest manufacturing facilities of the company. The company may have 10 facilities, but one of the biggest ones is mortgage with the bank. So it's important for the investor to know, right? Consent requirements. Invariably, your bank documents are going to have a requirement for obtaining prior consent whenever there is any change in shareholding in the target. Okay. So please watch out for consent requirements. It will invariably be a part of your finance documents. Third, ROC compliances. Now, many a times when there is a charge which is created on a property, for example, there are some compliances that you need to make with the ROC. This you may have even seen as a part of your company law. But if you have not, when you come to the loan section, you will realize that there are something that you need to see. Okay. Stamp duty. Again, whenever there is a contract, stamp duty is going to come behind you. Okay. So like it or not, it is something that you're going to verify. It is something that you need to check whether it has been adequately done, especially if there are loan documents. See, you can be rest assured. Okay. Practical tip. You can be rest assured if a bank's doing it, it's not going to be like non-compliant per se in terms of stamp duty, but just be mindful that it's been done. Okay. Now, some tips on how you can tackle this section of your diligence process. Okay. Check the financials for the real picture. Like I said, I always pick up the financials first because I like to be well informed. And I hope you do the same thing when you begin a diligence, because you will know, like there's a specific section, there'll be notes to accounts. It will tell you everything about the loans taken by the company, security, everything. So you will literally map that with the documents provided to you. So, and if there is something which you see in the financials but not in the papers, you are equipped to ask the company about it. Okay. Ask for a summary on the indebtedness position. This is what we call a balance outstanding position. Okay. Always insist on the management giving you a summary on all the present outstandings. Now, they may have taken a loan of say 100 crores. Okay. But what is important for you to tell your client is today there is an outstanding of 70. Okay. Why is it important for the investor to know? Because it basically means that 70 is going to be an outflow from the company at some point, which means the value of the company is coming down by that much, right? While they may obviously have taken this into consideration when they do the valuation, but it's important to always obtain a balance outstanding position to understand what is the potential outflow for the company towards repayment of its debts. Okay. So please keep these tips in mind when you do the loans section of the report. Now, the next most important part after contracts, more often than not, I see juniors saying this is another very vast part of the diligence process. And, it takes some time for you to kind of understand how you have to go about this. So this is nothing but understanding more about the employees and the structure of the employees and, how generally human resources work within the target entity. Okay. So what are the documents that you're going to usually cite under this section of the diligence? Organization structure, very, very important. They will tell you exactly the hierarchy. It starts with CEO, CFO, department heads, everything. You need to understand how the layout for the company looks like. Employment agreements, especially your promoters and KMPs. KMPs is what we call key managerial personnel. They are very, very instrumental to the company. So you must have a look at their agreements. Okay. Now I have seen instances where these small things became very, very important because I remember it was a pharma company and there was a research development officer, and he had like a one-page appointment agreement, which was their sample format of 1990, which they have signed with a guy in 2005, for example. You can't have the same level of, for somebody who's creating products for you, who is making the mixtures, who is researching, and who has so much, he's the guy who holds the IP for the products that you're making. So your agreements have to be very robust in terms of confidentiality, IP protection, so on and so forth, right? So important for you to highlight to your client as to the quality of employment agreements, right? Is it enough for, protection for the company in terms of IP? So employment agreements, very important. Employee benefits. Now here you have statutory and non-statutory benefits. Statutory is your provident fund, gratuity, employee state insurance corporation, all of these payments that or provisions that the company needs to make as a part of the requirement under the law. The non-statutory benefits are usually benefits which the company voluntarily provides, right? It could be HRA, leave encashment, travel allowance. It's important for you to know all this because it's important for you must think, why is all this important? It's very important because they want to know who's being given what benefit. Is there somebody who's getting more? And is there somebody in the same position who's not getting those same purposes? Okay. So understanding this structure is very important. Company policies. They will typically, if it's a good group and a lot of entities under it, they'll have like a nice, robust policy on everything under the sun. So always keep an eye out for that one. Loans to employees. Many a times there's a practice of giving loans to employees. So it's important for you to understand if that has been extended and what are the terms on which the repayments happen. POSH Act compliance, Prevention of Sexual Harassment Act, has taken a lot of importance over the recent years because the consequences under that for non-compliance are pretty much, it's quite onerous. So it's very important to comply with this act. So this is also something that you must always keep your eye out for. Always check if committees have been formed, if there are external members, if reports have been submitted as per the act. Always be cognizant of POSH Act compliance. Okay. What are the most common observations which come out? See, again, there are a host of things that which form a part of issues and observations. Okay. I have just tried to capture here something that you will typically find when you review, say, a particular section of the report. Like in my experience over the years, something which keeps recurring, something which is very usual, and something which keeps happening over and over again. Okay. Past employee claims. Very, very important. Okay. Your investor is not going to live with a disgruntled employee somewhere filing a case. No. Okay. It's very important to understand if anybody has been terminated, if full and final settlements have not been made for an employee who's been terminated, if there are any employee related litigations pending. Very, very important for you to note. Statutory non-compliances, like I mentioned, there are a lot of benefits, there are a lot of requirements under labor laws. If they have not complied with, say, paying a premium or making a payment or making provisions in the books, that's something that you need to identify. ESOPs, very, very important if they indeed have ESOPs, okay? You must be able to understand to whom ESOPs are granted. What is the total percentage of the shareholding that has been kept aside for ESOPs? It's very important for the investor to know that, because that means to that extent, there is some portion of the share capital that has already been kept aside. Okay. So this is something that they're definitely going to want to know. They're going to want to know the terms of the ESOP scheme, the stock option scheme. Who is eligible for the stock option scheme? Many a times, as a part of the transaction document, you will see investors wanting to rewrite the whole stock option scheme and things like that. Okay, so ESOPs are a very, very important part of your human resources section of the diligence. So this is what you're going to commonly observe as issues. Some tips on how you can tackle this section of the report. Obtain a breakdown of the category of personnel. Okay, what I'm trying to tell you here is a company could have employees, a company could have consultants, a company could have casual labor, a company could have contract labor. Then, you have some freelancers. So it's important, different laws apply to different categories of personnel. Okay. So it's very important for you to get a breakdown of the category of personnel so you know you're looking at the right laws in terms of compliance. If the target operates out of several locations, get a location-wise breakdown. Okay. If there are 30 locations from where a target operates, okay, it's important for you to know how many people sit in each location. Why? Because a lot of labor laws are state specific. So you will then have to not only look at central laws, but also state laws to see if each of those locations are complying with the labor laws which apply on a state level. Okay, so getting that list is also very important. Check if KMP and promoter agreements are in place. I think I dealt with it when I was discussing the employment agreements, where I said, why it's important to understand that the agreements are appropriately drafted or they're enough to protect the company from any infringement of IP and things like that. Check for templatization of employment agreements. Again, it's important. Now, if they will just, like I said, they'll do a data dump. They will say we have 500 employees, and before you know, there will be 500 employees employment agreements uploaded for you in your virtual data room. That's not what you want. So the question you need to ask the management is, are they all drafted on the similar lines? Responses you may get is yes. Responses you may get is no. If it's very senior level, this is the agreement. If it's somebody at this level, this is the agreement. So in that case, you just need to pull out templates of people at those relevant levels, right? And then just look at those templates and take a representation from the company and put it in your report to say that we've been informed that they are normally drafted on the basis of these templates. Okay, please understand that your client is not expecting you to see 500 agreements which look alike. That's a sheer waste of time and effort. Okay, so you need to ask these questions to the management and take a call on how you want to review these documents. This is how you make your review process simpler. Okay. The next important section is licenses and permissions. Again, this can become a very overwhelming section of the report if it is a company which is very intensive in terms of licenses and permissions. Okay. Again, depends on the business. It depends upon the company on whom you're going to do a diligence on and the business it's involved in. Okay. So some documents that you will typically see under this is business specific registrations. Okay. So for example, if it is a company which is involved in, say, it's kind of involved in the manufacturing of alcohol, then you will have environmental licenses. You're going to have license to operate a distillery. Then you're going to have a Factories Act, host of licenses when you're into manufacturing. Okay. So that is what we call business specific registrations. That is registrations which you obtain because you're a part of that business. Then the other category is other statutory licenses. Now, for example, you have a shops and establishments license. That is something that you take whatever business you are in. Okay. That's something that you need to take the minute you open an office, depending on the state you are in. So those are what we categorize as other statutory licenses. What are the common observations that you see from reviewing documents in this section of the report? Okay. First and foremost, always check if the license is valid. Okay. You have to check if the license is valid or it has expired. License is not obtained for all locations. Like I gave an example, if there are if there is a company which is operating out of 20 locations, you need to meticulously ensure that you are categorizing the information on the basis of location, and you're ensuring that all the licenses that you see are actually there. And if there is something which is not there, that's the issue that you point out to your client. Okay. Intimation to authorities. Many a times licenses will have terms in them which will require some compliances from the target entity if it wants to take investment. So for example, I can just think of one example right now, like the importer-exporter code. Okay. They usually have a term to say that if there is going to be a change in control or a change in management of the company, then an intimation needs to be made to the DGFT, that is the Directorate General of Foreign Trade, within a period of, 30 or 90 days from the date of the investment. So these are things you should be telling your client, because these are things you need to do rather to keep the license operative. Okay. Past non-compliances. Another very, very important part to always be aware of. ask for notices that they may have received from third parties. Okay, ask if they have received any default notices because they have not obtained any licenses. So these are things you must always keep an eye out for, to check if they have. See, today you may have a license, but you must always ask them if they have been held liable for any non-compliance in the past. Okay, so that's a question that you must always pose to the management. It will be a part of your checklist, but always ensure that you have an answer for it. Now, some tips to navigate through this section of the report. These tips are mostly when you are doing a diligence of a company which is very license intensive. Okay, I remember I have been a part of a due diligence of a company which had IVF clinics all over the country, 30, 35 plus locations. And I remember the minute we got the mandate, as a team, we started looking at, we asked the company for a list of all the locations. In fact, I think we got access of it from the website, and we actually started mapping all locations, started looking at central laws, then state laws, then local laws to see, because this is an important business, okay? In the sense you're talking about dealing with life. It can get very difficult if there is any issue anywhere in terms of non-compliance. So you have a license to run a clinic, the licenses for the doctors, the licenses for the gynacs, licenses for the nurses, then you need to have the right equipment in your clinics. You need licenses for each and everything in every clinic. So you can imagine what kind of an exercise it was. And it was a strategic 100% investment, if I remember correctly. And there was no way, as far as licenses were concerned, the client was clear they did not want sampling. Okay. So we had to be completely prepped in terms of what we wanted to see. So always do your homework when the business is license intensive. Very, very important for you to have a quick, to have a detailed check on all the laws that will apply, make a list of the laws, make a list of the licenses, and the minute the information is provided to you, keep ticking that you have actually seen all of those. And if you've not seen something, please feel free to check with the management why a particular license is not there. You'll be very surprised that they may not even know that such a license is needed at times. Okay, so always do your homework when you're going to have a look at companies which are inherently very intensive in terms of business licenses. Location mapping is critical. Connected to my previous point, especially if you are going to look at 30 locations. Okay, it's important for you. Like I said, in India, we have central laws, state laws, local laws. You have to be on top of every law applicable to every location if licenses is a critical part of your diligence. Okay, like I said, when we did the diligence for the company which was running IVF clinics across the country, location mapping was the key for us. Okay, it is very important for you to know, okay, where is it operating, which state is it operating, which is the location it's operating. Check local laws. If you want, reach out to local lawyers, get some more understanding. But that is an exercise you have to do, according to me, even before you begin the diligence. Okay, so the minute you see something, the minute you know you're getting into a diligence which is license intensive, please do your homework. The next section of the diligence is real estate. And I think some typical documents that you will see here is, you'll see documents in relation to owned property, leased property, licensed property, other premises that the company occupies, right? Everything in relation to the property held by the company. Now, the most common observations here are stamp duty issues, registration issues, okay, validity of the contract. You need to see if the contract that they have for a property is actually, within the term, termination rights, consent requirements. I think this is a kind of an overlap with what I discussed on the contract. It's like analyzing any contract to see if there is anything under that agreement which can lead to a termination because the investor actually invests in this entity. Is there any consent requirement from any counterparty because the investor is going to invest in the entity? These are the questions you have to ask when you see a contract under real estate also. Okay, some tips over here in terms of real estate is, if a document is registered, please don't go sit around verifying stamp duty. You have to assume that the sub-registrar has verified. The sub-registrar will never register a document if adequate stamp duty is not being paid. So please save your time, and if it's a registered document, please don't go around checking for stamp duty. List of locations, nature of arrangement, ask for a summary, always. if there are a lot of premises that the company operates out of, it gives you a clear idea on what are the documents you need to ask for. Sharing of premises between group companies. Many a times you will see situations when premises are being shared. Say the holding company will actually own a piece of property and all the subsidiary companies will show the registered office as that. So you need to have appropriate arrangements to show arm's length, etc. So you need to always ensure that if there is a sharing of premises between group companies, it's accurately documented. These are the usual things that come up when you do bigger diligences. So always keep an eye out for that. Then the next section of the report is intellectual property. You will have, like the name suggests, there's trademark, there's copyright, domain names, patents, if there are any licensing and sub-licensing arrangements in relation to any IP, right? All of these documents will be provided to you as a part of this section of the diligence. The most common observation is who is the owner of the IP. Many a times you will see that it is not the company, but it's actually the promoter of the company who owns the IP. So these are things that's very important for you to let the investor know, because then they may usually want the IP transferred to the company, right? Because the IP is critical to the valuation of the company. Then, those are things you need to point out. And of course, the validity of the registration. Is the registration valid? Usually you'll have like 5 years, 10 years, 12 years. You need to always ensure that the IP is valid. Okay. Some tips for you to navigate through the IP section is always, again, get a summary. Summaries are honestly something that you must try and obtain for every section of the report if it's robust and very, very vast. Run an independent search. Like I mentioned in the beginning, even you can run like MCA, you have trademark registries, patent, websites where you can get information firsthand about things. So it always helps for you to run a check to see if all that's provided to you is it, or if there's something more. And the last section, which you will typically find as a part of your due diligence, is litigation. Okay. Now, this is usually proceedings which are initiated by the target entity or initiated against the target entity by some third party in several forums, right? It could be an arbitration, it could be district court, civil court, criminal court, magistrate court. Okay. So you need to ask for all documents pertaining to the litigation initiated by or against the company. Then sometimes you may also have employee-related litigations where, say, an ex-employee has raised some claims. I think we've discussed this when we discussed the employee section, but again, something that also is commonly seen. Common observations under this is always status of the proceedings. You need to see where it is and how far away is the proceeding in terms of of the proceedings actually getting concluded. Potential liability, you must try and assess. It's a little difficult sometimes, but you must try and maybe get the company to tell you what is the potential liability that they expect. This is more about when their proceedings initiated against the target, right? So if the decision is not in favor of the target entity, what is the potential outflow of money or payment that the target envisages, is something that you must always check with the management. This is very important for the investor to know, because this helps them in assessing potential liability, which will in turn impact valuation. Okay, so it's important. If it's small, they let go. If it is something massive, they will be very curious, believe me. So it's important for you to know the potential liability, especially when there are proceedings initiated against the company. Now, some tips to navigate through this. My perpetual tip, this seems to be like a perpetual tip in all my pro tip slides: ask for a summary for all pending litigations. Okay, we have been a part of diligences where there have been 25-30 litigations under under different forums, and we always ask the summary. We have gone a step ahead and even spoken to the lawyers who are actually defending those proceedings to understand more. So please do that if you think there is a need, especially if it's a high value litigation. Request for a potential liability assessment. I already discussed this, why you must check this with the management. Ask the expert. Okay. Now, here I'd like to throw in an interesting example. I know we're running out of time, but I really need to say this. I was a part of a diligence for an alcohol company, and there actually was a very massive litigation pending against a competitor regarding the brand and IP of whiskey that was being used by both of them, and it was kind of deceptively similar and everything. That that whiskey, the sale of that whiskey constituted about 35 to 40% of the revenues of the target. So the investor was very, very curious to understand where this litigation is going to swing. Okay, so while we did an initial assessment and told them that this could be the potential liability, and in fact they were the first users of the trademark, so the possibility of them winning the litigation was quite high. But the investor actually went ahead and took a legal opinion from a senior IP counsel and took it on record to be placing it before his investment committee, to be able to tell him why they are still taking the risk of investing in the entity in spite of such a heavy duty litigation being pending. Okay, so it's very important for you to understand the impact of litigations, because more often than not, we are not, I mean, if you are a transactional lawyer, you may know some things, but you may not know everything. Okay, so it's important for you to present it. It's important, like I said, for you to reach out to counsels who are defending these litigations, explain it to your client, and many a times, if you think that they must take a legal opinion to understand implications, then that is a call you will invariably have your seniors and your partners take when they understand the issue a little more. And it's very interesting to be a part of these discussions as juniors. And I remember, we had brief senior counsels, we had a very detailed analysis on this, and ultimately took an opinion and placed it before the IC, and the deal went through. And after the deal went through, we got a favorable decision in our favor on the brand. So yeah, I mean, you must always, I think somewhere instinctively you will know when you need to be careful. And that's when you know you're getting good at doing due diligences. So keep your eye out for issues like this and always make a potential liability assessment. Okay. Now, I'm going to quickly run through the report writing process. This is the last leg of our discussion, and I can already see we are running out of time. I'm sorry, I'm going to hasten through this. How do you write a report? Okay. अभी चलो issues देख लिया, identify कर लिया, you know कहाँ पे क्या issue है, you've discussed it with your seniors. Now they say चलो start writing the report. What are you going to do? Okay. Every organization will have its own format. Okay. So please stick to that. But what I'm trying to tell you over here is what would typically be a part of that report. Okay. So for example, firstly, you will always have a background. You will always start with saying this is the date of the report. This is the brief summary about the companies that we've covered. Who is going to receive the report? Very, very important. There can only be one recipient to the report. Okay. You are writing it for the investor, your client. It's not for the world at large. So please be very clear on who the recipient is. And largely, what is your report going to look like? What are the contents? After you set out the background, the next thing that you're going to do is tiny things like cutoff date. Like till what date have you undertaken a review of the documents? Areas of the diligence. We've already discussed that in substantial length, so I'm not going to bore you with that. Glossary. Okay. You are going to use tons of abbreviations across your report. So please keep a very concise, alphabetically organized glossary, which makes it very reader friendly for your client. Okay. So that's going to be step 2 of preparation of the report. Then information received. Now this is going to be like a factual reproduction of all that you've seen across every area of the diligence. Okay. You're going to set out factual positions under every area. You're going to make cross references wherever relevant. So to give you an example, when you start drafting with company law, okay, you're going to start saying that this is the name of the company's name changed from this to this is the date of incorporation, this is the paid up capital, this is how shareholding changed over the years. So you're going to present a complete, you're not going to start writing issues. No, that's not how it works. You are going to start presenting to your client what exactly you reviewed or how exactly information has flowed for you under a specific section of the report. It's very important for the client to see that. Okay. So you're going to cover all of this when you set out factual positions under every area of the report. Then the most important part of the report, which is documenting your key issues. Okay. How do you document your findings? Okay. Firstly, describe the issue. Now, like I said, there are various ways to do this. Every firm, every organization is going to have its own format of doing it. But more often than not, the how you have understood an issue is understood by how you draft the issue. Okay, it's very, very important for you to draft the issue in a manner which is reader friendly and in a manner. See, please understand, the investor is not a lawyer. Okay, he has not done the diligence. The management of the investor has not done the diligence. You have. So you may know a lot of things, they don't. So always follow what I call the FICR approach when you draft an issue. Okay, first F, set out the facts. Okay, second, what are the issues that you see because of those facts? C, consequences of non-compliance or consequences of those issues. And fourth, what are your recommendations as a lawyer for the investor to do because you have spotted an issue? Now, let me give you an example on how this FICR approach would work. Okay, now your target entity has not obtained shops and establishment license for a particular premise in Maharashtra. Okay, it's an issue. Now, how are you going to draft it? What is the fact? Company A occupies premises located at dash in Maharashtra, Mumbai, Maharashtra. That's your fact. What is the issue? Company A has not obtained a shops and establishments license for that particular premise in Mumbai, Maharashtra. What is the consequence? A penalty of rupees XYZ will be liable as per the provisions of the Bombay Shops and Establishments Act in case licenses are not procured. Okay, so you have told the fact, you have told the issue, you have said what the consequences. Now, the most important part, what is your recommendation for the investor in terms of dealing with this issue? Recommendations are of varied nature. Okay, there are 4 types of recommendations that you will typically give as as a lawyer for your investor. First is conditions precedent. Okay, most of these recommendations are going to be documented in the transaction documents. Please understand that. Okay, so what do you mean by conditions precedent? It means you are telling the investor that something can be done even before the investment is done. What is condition subsequent? You are saying you will recommend to the investor that this can be done even post investment. Okay. Third, representations. So sometimes you may want to take representations from the company. So for example, they have told you that all distribution agreements are similar. Okay, basis that you have done a sampling. You will want a representation from the target entity saying that all of them are standard in nature. Specific indemnity. So this is very, very, very important. Okay. If there is something, when do you recommend specific indemnity? If there is something that cannot be rectified by the target, or if there is something which, even if it is rectified, could attract severe consequences for the investor post his investment in the company, then this is what you would recommend. That is, you will say, please seek specific indemnity for this particular issue from the target entity and the promoters. Okay. So these are the 4 kinds of recommendations. So in the shops and establishments issue, for example, which I gave, right, where I said that this is the issue, this is the consequence. The recommendation you can give there is this license needs to be obtained as a condition precedent to the transaction. Now, I know that taking the consequences, the penal consequences are very little. It's like a very meager penalty of, I don't know, $1,000, $2,000. Okay. So I don't want the investor to say, no, go take indemnity. I know this is an issue which can be rectified. Okay. So this is when you discuss all your issues with your senior, especially when you're a fresh lawyer. Discuss all your issues. Tell them. Many a times you may say, no, we should make this a specific indemnity. And your senior or partner with his or her experience would be able to tell you that, no, this is not a big issue. Let's put this in as a condition precedent instead of a specific indemnity, because let the company achieve it before that. Then the non-compliance is over. Okay. So it's very important for while these are largely the 4 kinds of recommendations, it is very important for you, once you understand the issues, think how you want to recommend and always run it past your senior to say that this is what I am looking to recommend. What do you think? Okay. Because in their experience as transaction lawyers, they will always know what needs to be given more weightage. Specific indemnities are usually a tough fight when you are finalizing your transaction documents. Okay. So more often than not, you have to be very careful, and you therefore need a lot of experience for you to be able to understand what should be a condition precedent, what should be a condition subsequent, and what needs to definitely be a specific indemnity. Okay. Last but not the least, after you prepared your full report and giving all your issues, the annexures to the report. Okay, when you prepare that information part right in the beginning, you're not going to put long charts over there. Okay, it's absolutely not reader friendly. All your charts, all your tables, all your observations always need to go as annexures to the report. Okay, it will have summaries of key documents, tabular information on a lot of things. You may want to just set out a tabular list of all licenses they've obtained, for example. All of that will go right in the end of the report. So this is how report writing is going to look like. Typically, end to end, the diligence process takes about 4 to 6 weeks. Drafting a report easily takes about 3 to 4 weeks, I would think, depending on the size of the company. So last but not the least, you will always end your report with something called scope limitations. Okay, it means this basically a caveat for you, disclaimers that you will give as the investor's attorney on what you have seen and what you have not seen. Okay, so some examples that we've set out here, like cutoff date. You are trying to say that you have only seen documents until the next date and not beyond that. So all your observations are limited to only that date. No independent evaluation. You will say we have not done any independent searches, so we have completely relied on the documents provided by the company. Jurisdiction. You will say you have only looked at all your issues and observations are only from the perspective of Indian law. Exclusions. You may say that you have not undertaken any financial, commercial, or business diligence, and this is a pure legal diligence. So again, all of this will be a part of the set formats that your organizations will give you. Different law firms have different scope limitations, but more often than not, these 4 or 5 points which we've just projected will always form a part of the scope limitations of your DD report. Okay. With this, we come to an end to discussing the whole due diligence process end to end. I know I rushed through a few things because I was falling short of time, but I think we should quickly take up our Q&A, Jinal.
Yes, definitely. So there are a few questions that we've picked up.
Okay.
So one of the question is addressed to you by Ankita Soni. She wants you to elaborate a little more on valuation support that we spoke about.
Okay. Like I mentioned, Ankita, valuation by itself is a topic which needs a separate session. Okay. There are different ways in which valuation is determined by an investor. Okay. It depends on earnings. It depends upon working capital. It's a very accounting process. It's not a legal process at all, but it is a very important determinant on what price is going to be paid by the investor to the target entity or the promoters when the transaction happens.
Hope that answers your question, Ankita. The other thing, it's from Nayanika Gupta. So she wants to know, why is residency status of shareholder important?
Okay. Residency status of shareholders is important when the transaction is going to be transfer of shares. Okay. So if the investor is going to invest in the target through a purchase of shares. Okay. So think of this as if the shareholders, the residency status of the shareholders is, say they're resident Indians and the investor is a non-resident, okay, then that attracts foreign exchange regulations. Okay, there are different methods of pricing of shares that apply when there is a purchase of shares by a non-resident from a resident, and therefore it's very important for you to know resident status in a share purchase transaction. If it's going to be a share subscription, then residency status is not as important. Investments can happen in 2 ways. Either the investor is pumping money into the company, or the investor is acquiring some shares by buying out some shares from the promoters or the other shareholders of the company. So residency status is more important in the latter.
Okay. So there's one more question, one question from Ipshita Singh. So she wants to know that how do you ask the management to rework their responses to the preliminary checklist if one feels they're not as exhaustive as they should have been? Okay, this all of us face.
Yeah, you are, like I said, you will invariably have this problem, especially if you're dealing with a management which is going to have a first-time investor. What I normally do, and I can only tell you from my experience, I don't believe in email exchanges. I pick up the phone, I schedule a call, I sit through the whole checklist with them, make my own responses, and then send it to the management for their consideration. That's what I do, just in the interest of time.
Okay. So one question from Chahat Jindal. So he asks you, he is like, can you factor like competencies of workforce and work culture be included in due diligence?
Not really. I don't think that really comes within the scope of legal diligence. It's Chahat. It's a very it's a very soft issue, you know. And like I mentioned, you know, the synergies, etc., is something that investors are very concerned with the senior management, and not really about work culture and all doesn't really form a part of. If there are disputes, abhi maan ke chalo, there's a manufacturing company with a trade union, and then there are invariably, you know, that there are issues going on with trade unions. All of those become very important for the investor to know. But otherwise, normally in a white collar culture, these things are not relevant for the investor.
Correct. One more question from Ankit Agarwal. He wants you to clarify the difference between sampling and templatization.
Okay, good question. Now, sampling is when, templatization is when, okay, let me take the same example that I did. Distributor agreements. Okay, a company is having 100 distributor agreements. They may tell you that nahi, sab kuch identical nahi hai. So there what you do is ask for a list and discuss with your client and pick up the top 10 in terms of value after you discuss with your client. There is no templatization. There is sampling. On the other hand, if the management tells you that हाँ हम तो यही template use करते हैं और सारे 100 agreement एक जैसे हैं, so at that time you can pick 2 or 3. You will automatically, when they start reading identical, you will automatically know, yeah, they're exactly the same, and then just take a representation from the management that they're all the same. So that's the difference between templates and sampling.
Correct. So there is one question from Harsh. So he would want you to throw some light on learning the drafting aspect during the due diligence in the position of an intern, quite specific.
I'm sorry, I didn't get that.
Okay, so he wants you to throw some light on how to go about the drafting of due diligence when a person is an intern.
See, there is
what's the expectation, probably, is the question that he wants.
Can I say something? The one thing that you can possibly do is read some old diligence reports that the firm that you're working in has drafted. Request for a couple of older drafts of the reports before you start drafting. Read older drafts of the reports to see what kind of language they use, what kind of how does the report look like, what are the typical issues under every section that you spot. See, like I mentioned with my experience, right, what are your typical observations under every section. See how drafting is not something you're going to learn overnight. Believe me, you will see those template reports and still you're going to make errors when you draft. Okay, so it's an ongoing process. There is no particular way out from this. But yes, looking at a few older templates of due diligence reports will surely help.
Okay. One question from Amarpal Singh. Is it okay to use a standard requisition and tailor it according to company, from company to company?
That's what you need to do.
Yeah.
So what you do is every firm, every organization has its own set of checklists. But when you customize it to company requirements, please be very, very, very careful that you're not pumping out things which should be there.
Hia wants to know more about ROC form filing. She wants to know what is ROC form filing.
Okay, so ROC is nothing but registrar of companies. Okay, you make filings with the local registrar of companies for every corporate action undertaken by the company, and if a compliance is required under the Companies Act. Okay. So to give you an example, if you see a board meeting resolution which says that XYZ director was appointed to the board on so and so date, there is a requirement under the Companies Act for the company to report that to the registrar of companies. Filings with the ROC is nothing but reportings made from time to time on certain activities undertaken by the company. Read the Companies Act, you will know more.
Jaideep wants to know, why is due diligence important? I guess we already covered it.
Lots of reasons. I gave them to you. You maybe joined in late. We spoke about risk analysis, valuation, understanding red flags, if there's a reason why, understanding synergies, you just realize you're just not a fit. All of this during the due diligence process is a long process. Okay, it's something that's exactly when the investor, the counsels, the lawyers, the accountants, they all start getting to know the company a little more. And please understand that your association with the company doesn't end with diligence. It goes till the end of the transaction if the deal is happening. So I think the investor somewhere gets a sense of whether this is going to work out or not, which is why diligence is important. It's a precursor to doing the deal. So yes, it's very, very important.
I think that's it. These are the more or less the questions related.
I hope I managed to answer everything and in a satisfactory way. And if there's anything more, I think Utkarsh, I'd be glad to answer things offline. If I could have a list, I'd be more than happy to just address it.
Sure, Deepti, sure. If we receive any more questions, I'll communicate that with you separately.
Sure thing.
Deepti, thank you so much. This was extremely comprehensive. I'm sure any user, any student who had, come in detail, watch the whole session today, he would get a very good nuance, very good understanding of the whole due diligence process altogether. It was extremely detailed. In fact, I would recommend all the students who have missed any part of it, right? Or if you, any kind of clarification you need, you will have the recording, or you will have this session. Watch it in detail, right? I think this will really help you out with your internship, with your placements, when you start working as associate. So thank you so much, Deepti. Thank you so much,
my pleasure,
for taking up all the questions.
Thank you so much for organizing this for us.
Thank you so much, Deepti, and have a wonderful weekend, Deepti and Jita. Thank you so much.
Thank you. Wish you the same.
You too.
Thank you,
Thank you, everybody.